Hi, very good morning. It's a Bombay High Court judgment, a very interesting judgment under the Customs Act. Ajay Industrial Corporation Limited versus Assistant Commissioner of Customs refunds. So, I am not going to give the full facts. As I proceed in this case, you can easily guess what is the fact. So, in this case, there are three parties involved. One is the importer, he is the petitioner. Second is the Customs Authority, and third is the Mumbai Port Authority. They are the respondents. The Customs Authority and the Mumbai Port Authority are the respondents, 1 and 2. Before beginning the judgment, Bombay High Court has given a prologue. Uh, it has been written by it. Bombay High Court says it is an unfortunate case of the AIC, Ajay Industrial Corporation, is the importer. Hereafter, importer says it is an unfortunate case of the importer. Despite having fulfilled all statutory obligations and paid customs duty, he is forced to approach the High Court due to prolonged and unresolved dispute between two government departments. Importer neither received the imported goods nor obtained a refund from the customs authority. The situation it will come. Caught between the two public authorities, importer was made to run from pillar to post. Each public authority was trying to put the blame on the other, and this importer is jammed in the middle. Bombay High Court said that the two authorities, that is the Customs Authority and the Port Trust Authority, were receiving taxpayers' money or public funds and therefore have no hesitation in raising various issues to delay the refund of customs duty after admitting that the importer is not responsible for the situation. Customs authority said that it is a case of pilferage after the goods landed in the port and when it was in the custody of port authorities. Port authority said it is a case of short landing for which they have issued a certificate and customs department must refund the customs duty. Bombay High Court said that it is a case of innocent importer suffering administrative inaction and interdepartmental discord. The authorities, instead of acting fairly and justly, have erected barriers of procedural technicalities and largely frivolous defenses, again utilizing the same public money. Bombay High Court then noted the sections. I am not giving all the sections, only some important sections. Section 13 provides that if imported goods are pilfered after unloading and before the proper officer has made an order for clearance for home consumption, importer shall not be liable to pay duty. So once goods are landed, it is either pilfered or lost. Then importer is not liable to pay any duty. That is section 13. Section 45(3) clarifies that if any imported goods are pilfered after unloading while in the custody of the port authority, for example, say port authority, it could be any other authority, if it is in the custody of port authority, the custodian, that is port authority, is liable to pay the duty on such goods. So there are three situations. One, according to me, one is goods imported and then if it is pilfered or lost, the importer is not liable to pay duty. Point number one, because goods are not cleared for home consumption. Second, if the goods are remaining in the custody of the port authority and if it is pilfered, then who is liable to pay duty is the port authority is liable to pay duty and not the importer. The third situation is if it is lost in the custody of or if it is short landed, then there is no liability on the importer. So in the present case, the goods were never cleared for home consumption and remained within the ambit of Section 45. Importer's liability for duty crystallizes only upon clearance, and if the goods are pilfered or short landed prior thereto, then incidence of duty cannot be attracted on the importer. Bombay High Court noticed that in this case, the importer was forced to approach multiple authorities, filing repeated representations, bringing out its grievance, only to face bureaucratic deadlock. Because this authority said you go to that authority said you go to this authority. It was going here and there, pillar to post. That is what the Bombay High Court said in the beginning. Bombay High Court said importer cannot be made to suffer indefinitely due to an interdepartmental tussle in determining or fixing responsibility for loss of goods. Section 23 mandates remission of duty on goods lost or destroyed before clearance, and Section 27 grants the importer the right to claim refund of any such duty paid in such a situation. In this case, the importer has already paid the duty before the clearance of goods. He knows what is the goods he is importing, what is the quantity, what is the value, and then calculated the duty and paid in advance. So that is why he wanted a refund, because the goods were never cleared out of the customs station. Bombay High Court said a combined reading of these provisions makes it clear that once it is established that the imported goods were never received and that proper officer never granted clearance, customs duty cannot be retained by the customs department. The duty collected in anticipation of clearance becomes refundable as it was paid without the corresponding receipt of goods. To hold otherwise, it would be contrary to both the letter and spirit of the statute and would result in collecting and retaining duty without the authority of law, not to mention unjust enrichment of the revenue at the cost of the importer. The court said in this case, the customs duty was not paid in response to a valid demand, but in anticipation of the clearance of goods that never materialized. Such payment, therefore, partakes the character of a deposit rather than that of a duty. So, in equity and under the statutory scheme, the customs duty must be refunded. The refund of such duty is a statutory entitlement. It is not a discretionary relief. Customs authority cannot say it's a discretionary relief. It is a statutory relief. The customs department, being the authority which collects the duty, cannot indefinitely withhold it on the pretext of unresolved internal dispute with the port authority. Bombay High Court rejected the customs department submission on the procedural requirement of a closure letter. They said you get a closure letter from port authority and then we will grant refund. The court said the closure of the bill of entry has become impossible due to unresolved issues between the customs department and the port authority and the shipping line. The three parties were involved. Importer, having done all that could be reasonably done or expected of an importer, he cannot be penalized for an administrative or procedural lapses beyond its control. The insistence on a closure letter in such circumstances amounts to denial of the substantive right of refund conferred by law. Then another contention of the customs department that was also rejected. The contention of the department was that the matter is pending police investigation. So let that the investigation complete and then we will grant refund. That was also rejected by the Honorable Court. The court reasoned that criminal investigation pertains to possible theft or pilferage and not in any way relates to the statutory right of importer to seek refund of customs duty. Importer's entitlement to a refund arises not from the outcome of the FIR, but from the admitted factual position that the goods were never delivered and bill of entry never attained final clearance. This fact has been admitted both by the customs authority and also by the port authority. Goods were never cleared. Goods were lost or pilfered. This fact remains the same. Whether the police finds it or not, that's a different matter. How much time it will take, that's also a different question. Then the final argument, the feeble argument of the customs department that the importer should seek alternative remedy by filing appeal, that was also rejected by the Bombay High Court. The court said there is no fairness in this contention. I repeat, there is no fairness in the contention that the importer should resort to an alternate remedy without customs authority even bothering to pass an order rejecting the refund application. The court said that this contention, perhaps it is raised only to prolong the importer's misery. Bombay High Court said it would be quite unfair to force the importer to await the resolution of the dispute, interstate dispute between the two departments. Hence, Bombay High Court ordered the customs authority to refund the amount along with the interest. The wonderful part is hereafter on. The Bombay High Court never stopped there. It also said you file a compliance report so that the importer is not forced to come to the court again for not receiving the refund in spite of the order of this Bombay High Court. So otherwise they will come after another 4 months, 6 months, and then they will not refund. Then this law has to file a contempt. Then they will come and say some other reason. Bombay High Court has nothing to you. File a compliance report, prove that you have refunded the money along with interest. That's the beautiful part of the judgment, according to me. Now comment. So I always add my small comment. One is this fight between the authorities went on for 3 years. This fellow is made to run from this fellow to that fellow, that fellow to this fellow for 3 years. Police to magistrate, police was not investigated. So he went to magistrate court, filed this thing, and then magistrate ordered the police to file FIR. So headache. Then another thing is this the coordination between interdepartmental authorities is always lacking, whether it is state or central. A road will be worst. You will be driving a car or scooter, bumpy road. Then one day suddenly you will find the road roller and then jellies and then tar, everything will be ready. So they will be making the road. Then you will be imagining, okay, on another week, a beautiful road will be there. So my car will fly. I have bought the best car, you will think. Uh, Hereafter, no bumpy rides. Even before the road is completely laid, then you will see another department coming with a lot of instruments for digging the road. Maybe it is for laying down water pipelines or electricity or telecom cables. Again, the road will come to the same condition. Why can't they sit and plan? Why there is no coordination in such activities? I don't know. This continues in India forever. Thank you very much. Have a great day.